Good morning. My name is Doreen Hartwell, and I am an attorney in Las Vegas, Nevada. Welcome, and we're looking forward to hearing your arguments today.
There we go. Good afternoon. I'm in Florida, so I'm on the other side. So it's afternoon for us. My name is Steve Jewett. I'm a county court judge in the Ninth Judicial Circuit in Orlando, in Orange County, Florida, and Disney World. And I am definitely looking forward to it.
Good morning from Oregon. I'm Erin Lageson, and I am a judge, the presiding judge of Department 3 of the Oregon Court of Appeals, which is Oregon's intermediate appellate court. Looking forward to hearing from you this morning.
And now you may introduce yourselves.
Hello, judges. It's great to meet you today. We are the Unified Representatives from Wauwatosa East High School, and we're representing the Wisconsin Wildcard team. We are coached by Mr. Taylor McDaniel, and our names are Audrey George, Izzy Marjorie, John Koch, and Sophia Hefner.
Okay, so I will now read the question. You will be answering question number 1 today. A result of the decision in Wisconsin versus Yoder is that, quote, any parent or guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religious beliefs. End quote. Do you agree or disagree with this result of the decision? Why or why not? What words, if any, are found in the U.S. Constitution or in state constitutions that protect the right to an education? And how have courts balanced religious beliefs with other rights? You may begin.
The concept of teaching the virtues of Pastafarianism, a religion that promotes the teachings of the gospel of the flying spaghetti monster in schools alongside evolution, is clearly absurd. In this situation, the government was justified in restricting the Pastafarians' right to freedom of religion within schools. The government should only have the ability to limit citizens' rights when their practice or action jeopardizes the common welfare of the surrounding community. The role that the U.S. government plays in restricting religion has been a long debated issue since the American colonization.
The United States was settled by pilgrims fleeing religious persecution under King James I. Due to this experience, the framers recognized the need for religious freedom within the American government. Thus, they created the Establishment Clause and the Free Exercise Clause of the First Amendment. There has been much debate within the courts regarding the protection of religious freedom while still promoting the common welfare of the culturally diverse United States, especially in schools.
The word education is never explicitly listed within the Constitution, thus making it an unenumerated right that is protected under the Ninth Amendment. In the United States, schooling is not the responsibility of the federal government, but is instead controlled on a state level because of the 10th Amendment. All 50 states mandate in their individual constitutions the provision of public education. Though the education system is left up to each individual state, the federal government has heavily intervened at times. After the Civil War, the federal government mandated that all Southern state constitutions guarantee a, quote, uniform system of free public schools, end quote. One example of this was the Mississippi Readmissions Act of 1870. The 14th Amendment has consistently reaffirmed one's right to education through the Equal Protections Clause in cases such as Brown v. Board of Education and Plyler v. Doe. Although the right to education is protected, more action needs to be taken on the federal level in order to ensure equality regardless of a person's income, zip code, or religion.
In the words of John Stuart Mill, quote, the right to swing my arms in any direction ends where your nose begins, end quote. This philosophy should be used when weighing the impacts of religious freedom over other rights within the courts. Conflict arises between religious freedom and the separation between church and state in schools often. In the case Jacobson v. Massachusetts, the court upheld the authority of states to enforce laws that required citizens to be immunized. For decades, all 50 states have required that parents vaccinate their children against various diseases as a prerequisite to enrolling them in public schools. However, while 45 states have tailored their immunization statutes to exempt those with religious and sometimes philosophical objections to vaccines from these requirements, widespread use of these exemptions threatens to undermine many of the benefits of mandatory vaccinations, such as preserving herd immunity. The common good should be put above religious objections because it now affects more than just one group of people. It affects and threatens the right to health of the entire school community, unlike in the case Wisconsin v. Yoder.
Religious freedom should only be infringed upon when there is a strong state interest and when the common welfare is threatened. Therefore, we agree with the ruling in the 1971 case of Wisconsin v. Yoder. As established in Sherbert v. Werner, an expanded version of the Sherbert test was used to determine that Wisconsin did not have a compelling enough interest to deny Amish students their traditional model of education. Chief Justice Warren E. Burger stated in the majority opinion, quote, however strong the state's interest in universal compulsory education, it is by no means absolute to the exclusion or subordination of all other interests, end quote. The common welfare was not jeopardized in this situation because the Amish community is independent and their actions do not directly affect outside society due to the isolated nature of their community. Although the right to education is protected within the US Constitution, they choose to provide an alternative vocational education that prepares children for their future adult roles. Forcing Amish students to attend public school until the age of 16 would only restrict their freedom of religion and would not benefit society. While public education is incredibly important, the state should not infringe on one's right to freedom of exercise unless it is of utmost importance to society. This concludes our statement, and we are now ready for your questions.
All right, thank you. So in terms of constitutional law, what does separation of church and state mean?
Separation of church and state means that the United States government or any government is not actively enforcing religion when they make decisions. And the framers really wanted this because, like, unlike in other countries such as England, there was a national religion or national church, meaning the Church of England. And because of the experiences that people experienced fleeing religious persecution, they decided to not enforce a national religion and enforce the separation of church and state.
The extent that church and state are to be separated has been of some conflict, as discussed in Wisconsin v. Yoder. Another case that exemplifies how much the state should be involved with religious activities is the case Zellman v. Simmons Harris, in which the government allowed vouchers to be given to students who go to private schools, which included religious schools. So that would mean the state is funding the church in an indirect way. But this was ruled constitutional because of the freedom to be educated in the way you wish.
Well, what are the advantages and disadvantages? Would there be any advantage, first of all, of having an established religion? And if the flip side of that, what would be the disadvantages of having an established religion?
According to the Pew Research Center, 4 in 10 countries have an established religion or a preferred religion. And America is unique in a way in the fact that we do not have an established religion. But some of the advantages are based off of the history, it's just important that we do have this freedom.
According to Pew Research Center as well, 70.6% of Americans are Christian, while 22.8% are unaffiliated with a certain religion. And the amount of Americans currently practicing a religion is declining in the United States. So I don't think it would be a good idea to have an established religion because it would lead to a lot of division in our country.
Well, let me ask you, just to follow up that, when the courts in Yoder, for example, where they said the Amish can violate the law and because of religion, are they not from time to time establishing to a certain extent or at least putting their imprimatur on a type of religion by saying, well, the Amish can do this because they are a legitimate religion, or we can have vouchers because that's a legitimate religion? What if it was like the Satanists or someone like that wanted to take their kids out of school in the 10th, when they're 10 years old? Aren't they saying that one is better than the other, and isn't that establishment?
Well, as seen in the case Wisconsin v. Yoder, the courts ruled upon the fact that parents were allowed to take their children out of schools because the Amish community is such an isolated community. According to Pew Research Center, about 90% of Amish people stay in the Amish community after the age of 18. Therefore, I feel like the United States was justified in enforcing this. Therefore, in other religions, like if one were to be practicing Satanism, that's a religion that those people who are members of the Satanic Church are still involved in society. Therefore, the government would have would be able to intervene and say, no, you do need to stay in school because you will be an active member of society.
And so just sort of a follow-up to that, to the extent that, and you stated in Pew Institute research shows that about 90% of the Amish remain in the Amish community after reaching the age of 18. But what about the 10% that leave? And to the extent that their education is limited, how should a student's right or their right to education be weighed against a parent's religious belief?
It is important that we value the children's beliefs and desires for their education. I personally believe that in the case of Wisconsin v. Yoder, the student's right to education is not being valued because at the age of 8th grade, it's difficult to, voice to your parents what you desire in your education. And in the case Prince v. Massachusetts, it ruled that the government has broad general authority over children and their decisions. And I think that it is important that we value that ruling alongside Wisconsin v. Yoder and really give the children an opportunity to have a voice in their right to education as well.
Additionally, those 10% of members who do leave have a difficult time finding jobs. Emma Gingrich was a woman who did leave the Amish society and ended up being a successful novelist, but in her book, she reported experiences of not being able to find a job because her skills that she knew how to do, primarily quilt making, wasn't applicable to regular society.
I'd have to disagree with my colleagues on this stance. And for example, in the case Meyer v. Nebraska, parents were given the right to bring up children in the United States under the 9th Amendment was established. So it would be an infringement on parents' rights to force children to stay in school longer than the 8th grade. And since the Amish community is already so small and 10% of those people would be undereducated, there are systems in our home state of Wisconsin to get your GED and go on to further education. It would just be harder for them, but the government has no right to enforce this on everyone.
You mentioned Jacobson in your prepared remarks, and I'm sure you're aware throughout this pandemic, there's been a lot of conflict between pandemic-related restrictions and to the extent that they apply to places of worship. How, if at all, does that decision inform the analysis of whether restriction generally applied to all sorts of businesses, but also to religious organizations violates the free exercise clause?
As long as the restrictions are placed equally based on all religions and businesses, then it would not be a violation of the Establishment Clause because each religion is giving fair treatment in this situation.
This goes in line with the court case Lemon v. Kurtzman, which established the three-pronged test, the Lemon test, which previously mentioned followed that as long as religion isn't inhibited or advanced in any way, or there is a secular purpose such as public health, then it is not violating the Establishment or Free Exercise Clause.
If I could go back to you were talking about the Meyer decision, Meyer versus Nebraska, where they found that the parents had the right to bring up their children as they saw fit. And you'd indicated that they should be able to decide. I didn't even get in. Okay. That's time. I had one more. Well done. Good job.
Yes, it was a great job. Stephen, did you want to give comments first?
Sure, I'll jump in. They're going to get tired of hearing this from me, but the hearings that I enjoy the most are the ones where it's like a conversation and I have obviously I had more that I wanted to talk to you about. We ran out of time. The time goes by so quickly because it's enjoyable. And that's clearly what we had here. I think that you guys have a very solid grasp of this. And what I really like is you've got the sort of brass tacks arguments. In other words, you're ready to talk about what it really means in the real world, but you also have the case law to back up what you're talking about. And it almost seemed like you had sort of you had your legal scholar and Mr. Koch up there who would throw in the sites, and then you guys are going, yeah, and what that means in a real world and applying it with there, it means this. And I think it's an effective, very effective thing. And the use of the statistics about the Amish and whatnot, because when I threw that question at you, it came right back and said, no, well, it's only 10% and all that kind of stuff. I think that's really well done. Excellent job.
Erin?
Sure. I would echo that. Your responsiveness was great. Your participation was well balanced. Your knowledge of the case law and sort of how it relates to our current circumstances was super solid. I appreciated your statistical knowledge, the fact that you've done your homework on the Amish community and had followed up on how Wisconsin v. Yoder, your home state's responsible for that case, had affected that community in the long term. And I thought you had a pretty developed understanding of the balance of parental power over children's rights. My only a small bit of constructive criticism, Isabel, in your prepared statements, you were super duper fast. Your response and your pacing in response to the questions was like Stephen said, a total conversation, and you seem much more relaxed. But I wasn't keeping time, so I don't know how close to the four minutes you are. But if you have, if you're not running up against the time, you could slow down just a little bit, because my brain was not quite keeping up because I'm older than you. Anyway, great job.
Yeah, I thought you guys did a great job. Your prepared remarks, I thought were really, really well done. I loved that you gave a truly historical background in your responses, and then you mentioned and then include the historical background in conjunction with express acknowledgement of the 9th and 10th Amendments and the impact on and the role it plays with regards to a right to education. You had lots of great evidence and a great grasp of the presidents. Your responses, as my colleague said, were responsive to the questions asked, and you truly applied the law, the rulings to your opinion. You used, I thought, good evidence in support of your arguments and logical, sound reasoning. Just great job, great participation by all, and good luck as you continue on.
You know, the last thing I just wanted to say too, you start out with talking about the spaghetti monster. That draws you in. I mean, that's a good start, because it's like, oh, where's this gonna go? Okay, great, excellent. So really well done. Good luck, you guys.
Thank you so much.
Thank
We
you.
appreciate it a lot.
Yes.